Hello and welcome back to another episode of the Injury Law Pod. I am your host, Eric Bartlett, 28-year personal injury lawyer. And this is the podcast where we talk about all things personal injury law related. And up today, it's summertime. And what does that mean? It means fairs, festivals, and with those, we have pop-up amusement rides. You know, the ones that you see driving down the highway on the back of a trailer, and then they're set up overnight in a parking lot. And well, sometimes things go wrong with those. And so today we're going to talk about some common personal injury claims from carnivals, fairs, and amusement parks in Missouri, and what people that have been injured at those need to know. So, as you can imagine, every summer, Missouri hosts dozens of fairs, carnivals, and amusement parks. But what happens when fun turns to injury? From ride malfunctions to greasy walkways, we're going to break down your rights if you get hurt at one of these events. So, what are some of the common incidents that occur with these festivals and fairs and the amusement rides that go with them? Well, mechanical ride failures, operator error, lack of safety restraints. Those are the top three. And, you know, there have been, again, these portable carnival rides that are transported and set up quickly. And obviously, a big one. I grew up in Sedalia, home of the Missouri State Fair. Every summer, I saw these rides put up quickly. I rode some of those rides. I'm still around to talk about it. But I do remember there were incidents where the rides would cause some type of an injury. Again, it's not common, but it does happen. You know, in November of 2024, there was an incident on the Copperhead Mountain Coaster in Branson. Two Texas women fell from a cart on the Copperhead Mountain roller coaster at Shepherd of the Hills Adventure Park, and they sustained life-threatening injuries, which included broken necks, spinal trauma, and this was after reportedly being ejected about 6 feet from the track. And again, that's actually a ride that is always in place. So you never know where or how this can happen. Obviously, on the Kansas side, several years ago, we had the horrific Schlitterbahn accident with the huge slide, and you know, the young boy was killed. And again, you just never know. So not only does it happen with these pop-up type rides, but it can also happen with rides that have been in place for a long time. With the Branson incident, the people that were hurt filed a negligence and premises liability lawsuit in federal court. They sought $50 million in damages. They claimed that the amusement park allowed two adults to share a single cart against the posted weight and age restriction, that they failed to secure the seatbelts properly, and that they allegedly covered up this policy on their website post incident. As of early January this year, investigations cite possible operator impairment, meaning for this particular situation, the operator was under the influence of marijuana. And as of this date, the lawsuit is ongoing. Again, with the Kansas situation, Schlitterbahn, most people are familiar, that resulted in a large $20 million settlement, and the complete doing away with that entire park. Schlitterbahn is no more. We here at Northland Injury Law have had a few cases against some of the local amusement parks based on either defective equipment, operator error. We've seen them both. So it does happen. Way back in 1991 at the Missouri State Fair, there was an accident involving the Gravitron ride. And this incident is still relevant for safety standards. The Gravitron ride malfunctioned and spun itself apart, and it injured 7 children. There was a multi-party lawsuit that followed against both the ride operator, which was Murphy Enterprises, and the manufacturer of the ride, Wisdom Manufacturing. And this resulted in stricter state safety codes. And obviously, it's a long time ago now. It's a reminder of how ride-related injuries can lead to significant litigation and regulation even decades later. And that's the same thing. Coming out of the Schlitterbahn incident in Kansas, it was determined that there really weren't a lot of regulations in place for rides like that. And as a result, more regulations went into place. So, the takeaway from all of these is that these attractions are fun, but they do come with risk, especially when safety protocols are ignored. We go there, we pay money, we expect the rides to be suitable for us and for our kids to go on safely, enjoy it, but that's not always the case. So, what about beyond the rides? What other types of injuries and accidents do we see? Well, as you might imagine, you've got everything going on at these fairs or at these amusement parks. You have food being served. There have been burns from hot food or equipment. There's been food poisoning that has occurred. There's obviously slip and fall hazards. There's whether it's, liquid on the ground, uneven ground, like poorly maintained premises, or poor lighting at night. All of these things pose hazards to people that are there to enjoy themselves. Again, with these temporary setup situations, there's often a lack of proper handrails or signage. And again, you've got cables that are strung across places where people walk, and sometimes those are not properly guarded, and those can cause people to fall, especially again if the lighting is poor at night. So again, there's a lot of potential problems. There's also been situations where children have been hurt, like with bounce houses, inflatable attractions. They collapse, they cause injury. There can be, again, a lack of supervision by operators, or a lack of fencing, things like that. So, what's the legal responsibility look like? Well, in Missouri, there is a duty of care that's owed to the attendees by the operators and organizers of these fairs, festivals, carnivals, however you want to describe them. So, who may be liable? Well, the event organizers certainly can be responsible. The ride manufacturers or operators, again, if it's shown that something was defective about the ride, or if the operators were not operating the equipment as it's supposed to be operated, if regular inspections were not occurring to make sure that the ride was in good condition, things like that. Again, on the food service side, if there's something that comes out of a food product, the food vendors may be responsible. And again, whoever owns the property that these fairs are being set up, they may have responsibility. Did they do their due diligence in making sure safety protocols were in place, that the premises were safe, things like that? So if you have a claim against somebody, most of these vendors, operators, property owners are required to carry liability insurance. And so hopefully, if you're injured and there is a claim to be made, there's going to be an insurance company behind that, just like you would find in a car accident or if it's a fall at a business or something like that, there's going to be insurance behind that. Unfortunately, as I've discussed many times before, insurance companies aren't always the easiest to deal with. They are for profit, and they're going to usually fight claims because the way they make money is they take premiums in and they pay out as little as they have to. And so, especially with these types of claims, what we've seen in our practice is it's going to require a lawsuit, and it's going to require expert witnesses because you're dealing with usually equipment and things that are outside the scope of the common person. And so you've got to have experts come in and talk about, again, whether it's the equipment, whether it was defective, whether there was something wrong with the way it was being operated, whether there wasn't sufficient warning to people that were going to be participating on the ride. All of those things come within an expert's purview to help define what the issue is, who should be responsible, those types of things. Now, again, just like with any other type of injury situation, if you've been hurt in one of these rides, obviously you've got to make sure it gets reported to the people that are responsible. And if it's a significant enough injury, that's probably going to happen because, again, this may be a situation where medical personnel are required immediately. The park, the fair, the carnival, whatever it is going to be on notice that something happened. And you obviously have to get medical attention quickly. And then the other key part of all this is some way, somehow, evidence needs to be preserved. There needs to be photos. If there's witnesses, you know, photographs or video can go a long way down the road. Because if you get into a lawsuit, you might be 2 years down the road discussing this incident. And, the expert witnesses, the potential jurors, whoever it is, they need to see what it was. What's the claimed problem here? And then also just in the lawsuit process, a lawyer needs to get the operating protocols, the maintenance protocols, things like that from either the operator of the equipment or the manufacturer of the equipment or both. You need to see what they had and compare it to what they were doing. And again, if there's a design defect or something with the equipment, there will be documentation as to how this equipment was designed, things like that. So all of that's going to become very important. And again, witnesses, obviously very important. If there's people there that saw the incident, saw the defect, saw the way it was being operated, whatever it is, very critical that the information they have. And also, it can be critical to know what employees were around, who was operating it. And again, you're going to want to know the history of inspections and things like that. And all that can be discovered in the lawsuit process. Something else that's very critical to keep in mind is if for some reason you're hurt in one of these situations, you don't want to sign any waivers and you don't want to accept any settlement offers on the spot. There's always the possibility that people start reaching out to you quickly about getting this resolved and trying to make some minimal offer to make it go away. Because again, as I've discussed before, once you settle, it's done. There's nothing more you're going to do about it. And so their incentive could very well be to get something done quickly and forever close the claim. But that may not be in your best interest, and it's probably not. At the end of the day, you don't know what the injury is going to look like down the road, what problems you're going to have, what further medical treatment is going to be needed. So there's no reason to rush to a settlement. And there's no reason to sign anything that's being put in front of you. You need to talk to a lawyer. These types of situations really require a seasoned, skilled personal injury lawyer who's handled these types of claims to come in and see exactly what the facts are and what was wrong and maximize the compensation that's coming your way. Now, again, especially with these fly by night operations where, again, they set up for a few days at a carnival or a fest, if you will, timing is important because all of this is very temporary, right? They're going to be moving on to the next one. And so the quicker you act to nail down certain pieces of evidence, the better. Because once it's gone, it could be gone for good. It could get repaired, all those types of things. So you want to be putting people on notice that you don't want that equipment tampered with until an expert has had an opportunity to inspect it. That's very, very critical. And again, you have to remember in Missouri, for example, you have 5 years to make the claim. So you've got plenty of time. Again, there's no need to rush towards a settlement or anything like that. Kansas, you have 2 years. So you've got time. And so you just don't want to be lulled into any pressure that's put on you by either the operators, um, the equipment manufacturers, or their insurance companies. So remember this as you go about your summer and you attend maybe one of these carnivals, these fairs, and you make the decision to participate in some of the rides that are put up there. You want to make sure that you feel comfortable with what you see, with the operators that are in place. I mean, do these people look like they're competent and qualified to be operating something that at the end of the day can turn out to be very dangerous? And again, if for some reason you find yourself in the position of being hurt by something at one of these fairs, then again, by all means, you can reach out to us, and we're always happy to take a look at the situation, figure out what the responsibility looks like, and make sure you're not going to end up with the short end of the stick. And so I always encourage you, give us a call. It's a free call, and we're happy to investigate any type of situation involving one of these carnivals or fairs. So again, enjoy your summer, be safe, and be well.